a pleasure to be with all of you this evening. My name is Stu Zimring. Stu, please, Mr. Zimring was my father. He was a very lovely man, but it's Stu or Stuart. And as you say, our mother's job is never done. My mother always taught me, I don't care what you call me as long as it isn't late for dinner. So here we are. What I want to talk about tonight, first of all, I'm an elder law and special needs attorney in Encino, California. I have been doing this now for 53 years. I am one of those rare individuals who does not work for a living because I love what I do. And if you love what you do, you'll never work for a living. So I'm really blessed in that regard. And in doing that, I have a partner who is the one who's eager to get me out of bed in the morning so I cannot go to work and still do all kinds of really good things. So what I want to talk about this evening is planning for yourselves and your loved one in a way that, as Judy was just saying, you'll know you've done a good job and not worry about it either now or after you're gone. So the agenda today is broken into a couple of parts. Goal one is to avoid crisis planning. I sometimes say, sarcastically under my breath, your crisis, your failure to plan is not my crisis. But of course it is when your failure to plan brings you to my office or one of my colleagues' offices and you haven't made preparations. So at a kind of 30,000 foot level, we've got conservatorships, we've got estate planning, which are bundles of documents and concepts and things we're going to do. But so how can we, and I'm going to break this into two segments. And as Judy said, don't hesitate to put a question into the chat box. I can multitask at a certain level, but managing the slide deck, saying what I want to say in the time I'm given, and dealing with the chat box are beyond my ability to multitask. So thank you, Judy, for handling that. So the first thing is avoiding crisis planning. And we do that, first thing, plan in advance. Now is the time. We all learned that, or a lot of us learned that, or had it refreshed for us during COVID. I hate to say it, but one of the best things that happened to my practice was COVID. All of a sudden, people woke up and remembered they're not immortal. Oh my God. So get the planning done, both for yourself and for your loved one. And that will take all the pressure off, or 99% of it. So planning in advance, what does that mean? I'm going to be talking about you, the parents, first, or if you are the person who has Asperger's or level 1, and I'm not sure what is the preferred term these days among your community, I'm going to say Asperger's. I hope that doesn't offend anybody. But you must have, at the very minimum, the following documents. You have to have an advance directive of power of attorney for healthcare. This is probably, in my opinion, for a number of reasons, if you have no other document, this is the most important one. Why? Because I am a firm believer in self-determination. I am a firm believer in self-control, especially where it comes to healthcare. And in the most basic, almost crassest way to put it, the way our healthcare system works today, if something happens to you and you are taken to an emergency room and you do not have an advanced healthcare directive that gives someone the authority to make other decisions for you, the healthcare team is going to pull out all the stops, hook up all the tubes, all the wires, run all the tests, and charge you for it. And that estate you carefully planned but didn't have an advanced healthcare directive for is going to be spent on those things which you may not have wanted in the first place. So that's why I say this is the single most important document. Next to that is a durable power of attorney for asset management. This is a document that will give someone the ability to make financial decisions for you, take actions on your behalf, pay your bills, do whatever it is needs to be done to keep the economic side of your world functioning, deal with the mail, deal with Social Security, whatever it is, they will have the power to do it if you are not able to do it, okay? And the third thing is, especially if you're the parent, especially if you are the partner of someone who's got Asperger's, have a nomination of a guardian or a conservator for your special needs loved one. So again, in terms of empowerment and self-control, you're going to be naming the person who is going to take over in that role as conservator or guardian if it's a minor, moving forward if you're not able to do that. In terms of what's it nice to have, what makes it a better package all the way around, a trust or a will. Very simply put, in California, if you have a house, you need a trust. In California right now, if you are married, or even if you're single, and your total assets, other than those which are joint tenancy or pay on death or whatever, exceed $187,500, then if you don't have a trust, that property is going to go through probate. Probate is not the end of the world. Probate is not a death sentence, but it is expensive, it is time consuming, and it is easily avoidable by having a trust. If you are married, then you may not even need a will or a trust, because under California law, if what you own is community property, everything you're going to own is going to pass to the surviving spouse. But that may not be where you want those assets to go. If your current marriage is not your first marriage, and when I speak around the country, other speakers are talking about the second marriage, and I generally say, I'm sorry, I'm from California. We are talking about the third or fourth marriage and the children who came from marriages 2 and 3. And it's a much more complicated picture in California. So you may not want, you may be under a legal obligation that certain assets go in different directions. And under those circumstances, absolutely, absolutely, you need to have a trust. You want to avoid the probate court at all possible. Not that they're nice people, but as I said, it's expensive, it's time consuming, and for a very relatively small investment, it can be avoided. And then at the end of the day, where we've got, I'm going to come back to this subject, you're going to need a special or a supplemental needs trust for your loved ones who has Asperger's or who may need it. And this is where the conversation really gets complex and complicated in terms of what kind of planning do we need to do for that person. And I'm going to stop here for 1 second because I'm going to take something of a deep dive before we launch into conservatorships and before we leave durable powers of attorney. And I want to open it up for any questions that may be there before I go off the diving board.
So are there any questions out there? Nothing is in the chat, but if you have a question, raise your hand. So far, we're all following you.
Oh my God, I've answered questions today. Okay, so I'm going to kind of reverse the equation a little bit. We'll be talking about conservatorships. We're going to be talking about limited conservatorships. We're going to spend a little bit of time talking about supported decision-making, but I know within the world of the Asperger's population, many, if not most of the people I've met in my life who I know or have been told have Asperger's are extremely high-functioning individuals. And so the question is, does this person need a conservatorship? The answer to that is extremely unique. It's kind of that question, if you have met one something, then you've only met one something. And I think that's particularly applicable to the Asperger's community. So the question is, when somebody comes to me and says, I think my daughter needs to have a conservatorship. I said, why? Well, she has Asperger's. And I say, right after that, let's talk about that. Why do you think she's going to need that level of oversight in her life? Because under California law, and for those of you who are legal wonks, if any, I'm talking here about Probate Code Section 811 through 813 of the California Probate Code, which talks about what is capacity. Someone says to me, well, my daughter doesn't have capacity. And I'm going to say that's the wrong answer to the question, because the way capacity is defined under California law is not capacity. It's capacity to do X. The law says, does this person have the capacity to do a certain thing? And the answer to that question is a set of sub-questions. Do they have the capacity to understand what it is they're doing? And do they have the capacity to understand the implications of that act? Okay? So if I've got someone who comes to me, just the simplest possible example, a person comes to me and they say, I have Asperger's, I want to write a will. Okay, I'm going to determine whether they have the capacity to do that. How do I do that? I'm going to say, okay, what does it mean to have a will? And they're going to tell me, well, that's a document that is how I leave my property to somebody. Okay, they've answered that part of the question. And I'm going to say, well, when you come to me and say you want me to write the will, what are you planning there? What's your thought process? I want to hire you to do it. Well, what does hire me mean? I'm going to pay you money to write a will. That person has capacity. Okay? So we apply these tests in each situation. If I've got a situation where someone wants to buy a car, and this is a case I've had, and the person goes to the car dealer and says, I want to buy that Maserati. And the dealer says, well, it was actually a Ford Bronco. That person says, sure, I will sell you a Ford Bronco. How are you going to pay for it? And he says, pay for it? Why do I have to pay for it? I just want to buy it. All right. Now we've got someone who does not have the capacity to sign that contract. All right. So under the law, this is a shifting question. But if your loved one, and I have any number of clients who come to me and they have very high functioning, either level 1, maybe even sometimes level 2, ASD, and Asperger's, and they say, does my son need to have a conservatorship? I'm going to put them through the drill of what I just talked to you about. And if I believe they don't need a conservatorship today, underlined, then I'm going to say no. I think they should have a durable power of attorney for asset management that gives you the ability to assist them or to make decisions for them. And I'm going to go through the same drill of healthcare decision making. And depending on their age, if they're still within the school system, I'm going to say, do you want to give your folks the authority to attend your IEP meetings, to have access to your records and your health records? And they say, yeah. And I said, well, do you understand what that means? Yeah, they can look at my CUME file. They can talk to my teachers. They can talk to the IEP team. I'm going to say, you don't need a conservatorship yet, but you do need these documents. And I've just saved my client, that family, easily 5 figures by not having to go to court for a conservatorship. Okay. So you can download these suitable documents. I'm not going to tell you great documents, but suitable documents, especially healthcare. If your doctor's office doesn't have the California Medical Association form, Advanced Directive Power of Attorney for Healthcare, you can go online. There is a great organization in Torrance called HELP.org. They've got some wonderful forms you can download and fill them, do it yourself. Durable powers of attorney for asset management. There are also forms available. I don't think they're as good as having an attorney draft them for you. Educational powers of attorney. Some school districts have a form available, others don't. I don't know about private schools. I can't help you there. But as I say, so capacity, as I was saying, is situational. As long as they understand the nature of the act and its consequences, you can totally avoid a conservatorship for the time being. And within that context, you've got the situation of what we now have in California of supported decision-making. And supported decision-making is a relatively new concept, but it is another step away from conservatorships. And it comes to us, actually the first state to ever have supported decision-making in its laws, much to my surprise, pardon my bias, was Texas. And it came to us back in 2023 as a result of the whole Britney Spears debacle. But what it does is it enables you, your loved one, to create a legally binding agreement wherein you have a supported decision maker who literally is your shadow, and helps you, guides you through the decision-making process of whatever those decisions can be. It can, like all of these things, it can be revoked at any time. It isn't a question. It's the flip side of what we are doing here is recognizing that the person involved is still an independent, self-sufficient, self-reliant human being who does have, we can call them limitations, we can call them challenges, and we're doing whatever we can to enable them to be as fully functional in our society as we possibly can, which is always the goal. And we're giving them those supports. But from my point of view, taking as objective a view as I possibly can, one of the flaws here in giving them that authority and giving them that independence is they can take it away. They can revoke the powers of attorney. They can revoke a supported decision-making situation. They can revoke the educational power of attorney. And now, if something goes south, yeah, we have a problem. I have yet to be in a situation where any of those things have happened with any of the clients that we represent, where we have gone down this course. We've got young, in most of the cases, young people who really want to be independent, but do understand their limitations or their challenges and welcome the assistance they're getting up to a point. We're talking about late adolescence and early adulthood, and this is a time where every kid is going to be pushing boundaries, and there is always that risk, and you know that as well as I do. I raised 4 children. I'm watching those children raise 10 grandchildren, and I see history repeat itself wonderfully on a daily basis. It gives me the opportunity every now and then to hear one of the kids say very quietly, yeah, you were right, but those are the wins you get occasionally. Okay, so this is the independence part, where we believe the individual can stand on her or his own 2 feet with some support, and we're happy to do that. And as long as everybody's getting along, this can go on for a lifetime. And the way you make it go on for the lifetime, Judy's point about, I want to say controlling from the grave, she's just saying being a good mother, even after the fact, is where in all of these documents, you build in what I call a deep bench. You don't just have that first person who's going to be the healthcare agent. You have 3 people behind them. And you don't have just one person in the durable power of attorney for asset management. You have 3 people behind them, and you have the mechanism there that automatically somebody's out, next person automatically steps up there and is able to fill in the gap and take it over from there. Okay, I'm going to begin to move into conservatorships for a while, and then we're going to get into estate planning and special needs trusts. So questions?
There is a question in the chat, Stuart. It's if the special needs person is unable to take decisions and nonverbal, can he do the advance directive power of attorney?
The answer is yes. The law is very specific. I mean, that is a great question. Because the test is, can they communicate the decision? Verbal is not a requirement. If there's someone who can communicate via an assistive device, whether it's a speaking computer, whether it's a signboard, whatever it is, I have communicated with people who communicate via eye blinks. And we get the questions into a yes/no format, and it's blinked twice. As long as there is an ability to communicate the decision, communicate the question, the answer is yes. One does not have to be verbal.
That's a great question. I have a question about the supportive decision making, I guess. Does that require a special document to define who that person is or how that will work?
Yes, yeah. Supported decision making is done with supported decision making agreements.
Okay.
And if this is something, it's not found in the probate code, even though it's part and parcel of the probate and avoiding conservatorships and all that process. It's in the Welfare and Institutions Code for some unknown reason. But if that's of interest, I can certainly send you some reference material on that, or some sites where you can see documents and some excellent conversations on the subject of supported decision making. But yeah, it's a formal agreement, and it does, in my opinion, require a somewhat higher level of decision making ability or a cognition, if nothing else, understanding on the part of the person with Asperger's, to keep it within this context, to understand the nature of the agreement. Because again, when we come back to capacity here, that it's situational, the more complex the issue, the more you run into the possibility that the person involved is not going to understand the consequences. From my point of view, in an estate planning context, if that person who came to me to write a will says, when we're talking, I said, so what do you want to do with your estate? Well, I got 4 kids. I want to leave it to my 4 kids equally. Perfect. No problem. But if I've got a situation where that person says, well, I'm very wealthy and I want to leave a lot of money to my grandchildren and I want to avoid taxes, I've heard there are taxes. All right, we're now into something called generation skipping transfers. This is an extremely complex situation. And if this person isn't in a position to understand the ins and outs of how the generation skipping tax works, then I'm going to be in a position of saying, I don't really think you should be doing this by yourself. This may be a place for a supportive decision maker, or actually it may ultimately be a place where there's some level of a conservatorship. And the reason I will tell them about that is you do not want to create a document that is subject to being attacked after you're gone. Or in these days in California, where we have something called pre-death will contests, we really have those, that it's going to be attacked. My job is to make your planning as bulletproof as I possibly can. So yeah, it does come down to, we have to look at the level of complexity. And, you know, there's a whole discussion on the level of capacity for writing a will is very, very low. You just need to know who the objects of your bounty are, general nature of your assets, and that this is what you want to do. A trust is a contract. The level of capacity there goes to this conversation. Do you understand the nature of what this document is? And so we now have case law says, well, if your trust simply does what the will would have done, I leave it all to my kids in equal shares, then it's a lot like a will, and we'll use that test for capacity. But if you're talking about these multi-generational transactions, we're going to apply a higher standard. And it just keeps getting murkier and murkier because people like to fight about these things, it being California.
So I'm going to suggest we pop up a level, Stuart, and continue with your presentation. There aren't any other questions in the chat, unless anybody else has any questions about what we talked about thus far. Okay, thanks, Stuart.
I do not mean to lay too much information on you in one meeting. All right, so in California, we have conservatorships and we have guardianships. In other states, a guardianship in many cases is for the assets of a person who has a disability, and guardianship is for the person who has a disability, and the conservatorship is for their assets. In California, we just have conservatorships for adults and guardianships for children. So I'm not going to talk about guardianships. Everybody I'm going to be talking about here is over the age of 18. So we have basically 3 types of conservatorships in California. We have a general conservatorship. Your mother-in-law, your grandmother, your father has Alzheimer's. He is no longer able to take care of himself, and he refuses to voluntarily check into the Green Acres Assisted Living Facility, and you need to put him there with a court order. You go in for basically a general conservatorship where you take control of his world. Okay? And that can be either of his person, his estate, or both. Okay? And it can be the same person as the conservator of the person and the estate. In that case, there has to be a full-blown determination that this person lacks the capacity, as defined in that statute I've been talking about, to make decisions all along all these different levels: healthcare, contract, medical care, where to live, what to do, all those things. And it's an item by item basis. And because we are depriving someone of their civil rights, the burden on the person bringing this petition, the petitioner, has a very high duty to prove that this person really needs it. And because this is stripping someone of their civil rights, if you look at the forms that are required to be used to grant this petition, among the questions that the petitioner is asked is, does this person have a will? Does this person have a trust? Does this person have a durable power of attorney for asset management? Does this person have an advanced healthcare directive? If the answer to those questions is yes, the first question out of the judge's mouth is, why does he need a conservatorship? You've got it covered as far as all those things. The answer is, dad refuses to voluntarily go into a skilled facility. He is a danger to himself. He wanders. We found him walking down, in my world, Ventura Boulevard, stark naked in the middle of the night. He's got to be in a safe place, and you'll get your conservatorship. Okay. Our community, those people with ASD at whatever level, they fall, or other developmental any level of developmental disability, they fall under the category of limited conservatorships. And here, unlike the general conservatorship, there is an ingoing presumption that we want to preserve as many of these persons' rights to take care of themselves as we possibly can. And so it's a very different process. There's a very different focus. The end is essentially the same. A conservator or co-conservators are going to be appointed for this individual, but the focus is truly on how many of this individual's rights can we retain for her. And since most, if not all of these people are regional center clients, regional center has a voice in this process, in addition to other people, the primary one being the healthcare provider for the individual. In both the general and limited conservatorship, once they are established, they go on forever. They do not terminate unless they are terminated, either by court action or by death. Under California law, there is a social worker who is an employee of the court called the court investigator. In both a general and a limited conservatorship, the court investigator is going to pay a visit to this individual, interview the family at least every 2 years, sometimes more frequently, depending on the case. And that person can activate court action. If they discover something, if they think something's going on, they can pick up the phone, call the judge and say, hey, you need to set a hearing to figure out what's going on here. Now, limited conservatorships, because they deal with a specifically defined community, it is much easier for an individual to do this themselves than retaining an attorney, especially if it's just the conservator of the person. If assets are involved, then generally speaking, you're going to need counsel to help you. But in Los Angeles County, Bet-Savick Legal Services, in conjunction with the LA Superior Court, runs a self-help clinic. They will help you fill out the forms. I do not know what may be available through the Orange County Bar or through any of the organizations out that way. But these are much simpler procedures to accomplish the goal than through a general conservatorship. The other last group of actual conservatorships are LPS conservatorships. These are for those who are drug addicts, alcoholics, bipolar, schizophrenic individuals, or criminals who are criminally determined to be mentally ill or insane. It is a whole different system under a whole different law. I'm not going to go into it at all, except to say they exist. If you hear of someone who's been put on a 5150 hold, that's the entry gate for an LPS conservatorship. If you have a family member, God forbid, who is bipolar, schizophrenic, drug addict, or an alcoholic, and I get a couple of calls every month from these families, can you help us start an LPS conservatorship? The answer under current law is no. LPS conservatorships are totally driven by the county public guardian and their attorney, county counsel, and the psychiatrist in charge of the facility where this person is being held. They're the ones who start the LPS conservatorship. Okay, I want to say a couple of other things on conservatorships, and then we can move on to talking about special needs trusts. If you are going to need a conservatorship for your loved one, and this goes kind of back to Judy's point about making sure things are taken care of even if you're not here, I strongly urge you to discuss with your attorney, or as you're applying for it yourself, to have both parents, if there are two parents, appointed as co-conservators. With the provision, if you can do it in Orange County, I know we can in LA County, that if one of them passes away, the other one continues on. It can be multi-generational. We are currently handling probably a dozen cases a year where there are existing limited conservatorships. Mom and dad are the co-conservators. They are aging. They want to make sure that their child with a disability is going to be taken care of. So they come to us and say, okay, we want to have our daughter or our nephew or our grandson or whomever appointed as a co-conservator along with all of us, so that you've got this seamless procedure over time. And that, again, as easy as anything is in the world where you're entering the room doors of a courthouse, is a relatively straightforward procedure. And if you have an existing conservatorship, whether limited or general, it's something I think you should consider talking to your attorney about. Last thing I want to talk about is this care court concept, which is brand new. We don't know a lot. We have not seen a lot of cases or matters coming out of it, but it is a diversionary program for people who would otherwise potentially qualify for an LPS conservatorship, but it goes into a supportive decision-making court supervised mode to help these people avoid being in that system. I'm not going to say anything more about that. Your family member, your cohort here, certainly I don't think qualify as needing care court assistance. Okay. Stopping for some questions.
Yeah,
And
so
we'll talk
Stuart,
about
you have questions. So here
Gee,
we
I'm
go.
shocked.
Okay. It is pretty complicated. Do you have an accepted shared decision form that you can share, please?
No.
Okay.
A shared decision. I do not.
Okay. Is such a thing in existence, or?
Oh, yes, they are. And I was actually, in prepping for this meeting tonight, I was looking at a couple. I will send you the links to some organizations that have suggested forms.
Okay. All right. That sounds great.
Yeah,
All
happy to
right.
do that.
Then the next question is, how do we create one specific steps? That's kind of, Savag, I think that's a really good question. I don't know if we have time to get into that. Can you do like a quick discussion of how would you
I'm
create,
sorry, what was the
how would
question?
you create a shared decision document?
The
How,
actual, okay,
yeah.
again, I'm going to defer because the one of the sites I'm going to send you walks people through it, how you do it.
Okay. All right. That sounds good.
Yeah, it's a negotiation back and forth with it. It's sort of like a guided conversation if you've ever been involved in one of those. But back and forth to agree on here's what you're going, sort of like, here are the kinds of things that you're not going to make a decision without checking with your supported decision maker.
Yeah.
And you agree that you won't do that unless you talk to me. And then we talk about it. And then, so it's back and forth, back and forth.
Okay.
But I'll send you those links. Yes, absolutely.
Okay, terrific. All right, then there's another question, and this is kind of a little case study here. Have you ever had a conservatorship where the court did their annual assessment a few years after approved, and the court thinks the individual no longer needs it, but parents disagree? Do you come across that often where the parents are stuck having to fight that?
The answer to the first part is no. I have never been involved in a case where the court on its own motion said we don't need a conservatorship. I mean, well, as badly handled as it was, I think Britney Spears is something that's out there that everybody knows about. The way that case ended is that someone, in this particular case, Britney, said, I don't need a conservatorship anymore. The court on its own motion, generally, I've never seen one, to answer the question. No, I've never seen one. When I've had, unfortunately, and a number of cases where parents have fought over the situation, usually they are divorced. And we have cases, I have had cases where one parent thinks there needs to be a conservatorship. The other one thinks that little Jane is perfectly capable of taking care of herself. That's what we have courts for. Actually, the only area within a conservatorship where someone is entitled to a jury trial is on the issue of capacity. And so if they want one in that particular case, little Jane can have a jury to decide whether or not she lacks capacity. Now, in that simple case study of dad files a petition for a conservatorship. Mom opposes the conservatorship. By the time that case is over, both sides are going to have spent a bundle of money. Where most of the cases arise is where Jane doesn't think she needs a conservatorship. And then it becomes a question of, there's going to be a trial. The parents who have brought the conservatorship are going to put the doctor on the stand. They're going to put witnesses on the stand testifying as to why Jane needs a conservatorship. Jane will get up there. She may have her own psychiatrist testify she doesn't need. And at the end of the day, judge is going to make a decision. It's a high bar. It's not as high as criminal beyond a reasonable doubt, but it's the next best thing. It's got to be by a preponderance of the evidence. So it's a high bar. But those kinds of cases are, in my practice, they don't happen too often, but they do happen. We had a case, the last contested conservatorship we had was right at the beginning of COVID. Elderly woman and her supposed boyfriend, fiance, he didn't want her to have a conservatorship. And she didn't know I mean, the day of trial, she didn't even recognize who he was. But it cost both sides tens of thousands of dollars, and didn't have to happen, but it did. Next question.
Well, let's see. I think that's it for now, unless anybody wants to raise their hand and has a question right now. There's a compliment.
I'll take it.
We love the way you explain everything. Great presentation, Stuart.
Well, thank you very much.
And positive feedback, so you can continue.
There you go. Okay, so now we're going to talk about special needs trusts and supplemental needs trusts and all those other good things. First of all, make life very simple. There is no distinction between special needs trusts and supplemental needs trusts in my world. They are synonyms. So don't even worry about, my grandson has a supplemental needs trust. Do we have to convert that to a special needs? They are the same thing. All right. There are two flavors at the 30,000 foot level of special needs trust. There is a first party trust, which is designed to receive assets that belong to the individual who is the beneficiary of this trust. John is involved in a altercation between himself and a car, and guess who loses? John loses mobility, but he wins big in terms of money. But this is his money. In order to preserve his public benefits, which is what this is all about, nothing more at this point in our conversation, we're going to put his money, as long as he is under the age of 65, into a first party trust. First party meaning it's John's money that's going into this trust. So there are litigation trusts, what I just described in terms of John versus the car. The proceeds of that lawsuit are litigation proceeds. That's a litigation trust. And there are non-litigation trusts. John's Uncle Bernie leaves him $100,000 in his will, not knowing that he should have done it in a special needs trust. Well, that $100,000 belongs to John. John needs to put it into a special needs trust for himself to avoid losing his public benefits. And the second kind of trust, basically, is what we call a third party trust. Had John's Uncle Bernie, rather than leaving him the $100,000 outright, set up a special needs trust for John, and the money gone into there, the net benefit to John would have been exactly the same. And we'll talk about that in a second, but it's not John's money. Parents who set up special needs trusts for their children who have a disability are setting up third-party trusts. It is not the child's money. The money is there for the benefit of the child, and it accomplishes the same goal, but there's a very, very big difference, which I'll get to in a second. An offshoot of this is a pooled trust. Okay, going back to John and his vehicle accident. Instead of $100,000, the car driver only had the maximum insurance, which was what, $30,000. So John gets a check for $30,000. In the world, that's not a lot of money. But John receives SSI, and John can only have $2,000 if he's going to maintain his SSI. And if he doesn't have his SSI, he will lose potentially his Medi-Cal. So we have to do something. But $30,000 is not enough to justify creating an individual first-party special needs trust. So what can we do? Well, the government gave us a gift. It's a miracle. And it enables John to create, it enables a charity to create a trust that functions sort of like a savings and loan. John can take his $30,000 and he can open what is called a pool trust subaccount within a larger ambit of this pool trust, which is collecting all these small settlements, inheritances, whatever they are, for the benefit of these people who would otherwise not really be able to benefit from a special needs trust. And pool, this is why it's called a pool. All John's money, other people's money is put into this pool. The trust is a special needs trust. It's valid under federal law. And John has his sub-account, just like he would have his savings account at savings and loan. And the trust, special needs trust, pooled special needs trust will make distributions for his benefit in the same way that a first-party special needs trust would make distributions for his benefit, or a third-party trust would make distributions for his benefit. But what they wouldn't be doing is making distributions for John directly. Okay, here's the reason. Under federal law, still today, and without getting political, for the foreseeable future, which probably means my lifetime, Medicaid benefits are considered loans to the individual. And if you're qualifying for SSI and therefore qualifying for Medi-Cal, if you, as we said before, if you have more than $2,000, you don't qualify, you lose your SSI and you lose your Medi-Cal. These trusts create a loophole. If your money goes into a D4A or a pooled trust, then in the eyes of the government, they have vanished, the cone of invisibility, and you continue to get your governmental benefits. Wonderful thing. But there's a very, very big asterisk here. When you die, when the beneficiary dies, when John dies, any monies left in that trust, whether it's a first-party standalone trust or a D4C pooled subtrust, goes back to Medicaid, Medi-Cal in California. SSI doesn't care, but Medi-Cal gets the money back up to 100% of whatever's left in that trust when John dies. Okay? This applies only to first-party trusts because first-party trusts are the only ones that are actually set out in federal and state law. They exist because it's John's money we're talking about. And John and the federal government is saying, hey, John, we will let you make that money invisible to us during your lifetime, but whatever's left, while we've been spending all this money on you with Medi-Cal and healthcare and all that stuff, we get back whatever's left to repay us for what we did for you. Okay? But as I say, it only applies to Medi-Cal, and it does not apply to SSI. SSI is a whole different thing, but they both have, excuse me, the same $2,000 limitation. Third-party trusts, the ones mom and dad set up, the ones Uncle Bernie set up, they don't exist in federal law because it ain't John's money. They don't care. The key element in all of these different kinds of trusts is that you can't put the money in John's hands. For SSI purposes, every dollar that goes into John's hands decreases his benefit by $1, dollar for dollar. So this is why every special needs trust you're ever going to read is going to say the trustee shall pay to or apply for his benefit whatever amounts that the trustee deems appropriate to assist John. So while it says it can give him money, no trustee in his right mind is ever going to give him money. They're going to use it for his benefit. Under the SSI rules as they exist today, the trust can pay for anything. You know, people ask me, gee, why are special needs trusts so restrictive? And I'm going to say you're reading it through the wrong end of the telescope. Because what the trustee, what a well-drafted special needs trust is going to say is that the trustee cannot make any distribution that will adversely affect John's public benefits. That means his Medi-Cal and his SSI. All right. Once upon a time, way back when, there were 3 no-nos that would affect SSI benefits. You couldn't make a distribution for food, clothing, or shelter. The government gave up trying to track people's clothing purchases about 20 years ago. Last year, they gave up trying to look into the refrigerator. So at this point in time, the only thing that the trustee of a special needs trust can't make distributions for are John's housing. That's what his SSI is supposed to be for. But that's a specifically defined item within the Social Security law. So the trust can pay for John's cell phone, John's computer, John's internet access, John's cable service, John's car maintenance, car insurance. The whole world is open to what the trustee can do in a special needs trust for John, as long as it doesn't give him the money to do it. John needs a new computer. John goes to Best Buy. John says, I want the Dell 3100, whatever it is, tells the trustee, please go buy me that. The trustee goes and gets it, doesn't give John the money, gives Best Buy the money. And we are very happy here. And that's it in a nutshell.
I'm just gonna, can I add something to that, Stuart? Because this is Judy. So not everybody knows about ABLE accounts.
Okay.
And what we do, because my son has receives money from a trust because my sister-in-law passed away and left him a 401k. And so what we do is every year we take the money from the trust, his distribution, and we put it into an ABLE account. And then from the ABLE account, you have a lot. First of all, that's not counted towards the $2,000, and you can spend that money on housing.
Exactly.
So,
Thank you.
So it gives you a lot more freedom. So that's kind of a handy workaround for that.
Absolutely. Absolutely. ABLE accounts are available for anyone under the age of 26. You can contribute up to this year $19,000 because that's it's $19,000 this year into the ABLE account. The asterisk at that point is that if you are in a position where you are making annual gifts, the $19,000 that you can make to anyone in the world without anybody, the government giving a damn, but that's considered the gift to John. So you can't put you can put $19,000 into the ABLE account, but you can't give John another $19,000. You can front load ABLE accounts. I think it's 5 years. There is a maximum limit that can go into an ABLE account. It varies from state to state, but you're absolutely right, Judy. The huge advantage of an ABLE account is that it is not subject to this restriction on paying for housing.
I hadn't realized that you had to set it up before the age of 26.
Yeah.
I don't think our members knew that.
I think that's still the rule.
Wow, that's really important because a lot of us are dealing with older children. Yeah. So
well, once it's set up, you can. Once it's set up, I will fact check
fund
that.
it or not fund it, but the
I will fact check that because there has been some legislation, but I think it may be changing, but I think it's still 26.
Yeah, because a lot of people find themselves, procrastinating and thinking, I'm not ready to make this decision. So this puts a little time pressure on them that maybe they hadn't realized was there. So thank you for letting us know.
My pleasure. God bless the internet. I'm sorry, I'm wrong. It's the disability has to have begun before age 26, and January 1st, that's where I was thinking of 26. So no, there's no limit on when they can set up the ABLE account, but the disability had effective January 1st, the age limit is 46. So the disability has to have occurred before age 46 effective January 1st, and 26 now. But no, the start date is not there. That was my bad. Thank you for calling me on that. So, okay. In the community in which we live here, the Asperger's group, where so many, at least in my perception, are very, very high functioning. The question is, do we really need to have a special needs trust? And my answer to that, based on what I was taught as the answer to every question anyone asks a lawyer, we learned that first day of law school, is, well, it depends. And another approach that I favor, where I've got someone who is high functioning, who may, especially depending on the age at which we're creating this, may be able of a greater level of independence and self-sufficiency. I like to recommend to my clients that we don't necessarily focus on the qualification for public benefits part, but rather we focus on exploring the opportunities we can make available for this person. And so instead of saying, for example, in a document, the trustee may not make any distributions that affect the individual's public benefits, I'm going to say the trustee can make whatever distributions the trustee deems appropriate to help this individual. But I want him to keep in mind that if at any point in time the individual is eligible for public benefits, not to do anything that's going to screw it up. I may be a little more fanciful in my language, but that's the goal. And I think it gives us a whole different way of looking at, my practice is holistic. I'm looking at the whole individual. I don't want my client's child to see this document and say, my folks didn't have a lot of faith in me. I want a document that's going to say, we're here to support you. We want you to succeed, and we're going to do whatever we can to assist you economically. But we also want to be mindful that, yeah, you may need some help. And if this document could get in the way of that, I want to make sure the trustee knows to watch out for that. So, where I've got now, there's a crazy right now asterisk to this. At least in California, from what we're seeing right now, if your beneficiary is receiving SSI or Medi-Cal, and the trust that is, by its terms, qualifies as being a special needs trust, no provision in there that gives regular payments to the individual, no provision in there that it is to be used for health, education, maintenance, and support. All that, quote, bad language is taken out of it. We have a number of cases pending right now where the trust has been rejected simply because it did not say in its title that it is a special needs trust. I mean, it's crazy and we're dealing with it. But so that's there. But I am trying more and more in my practice where we have the appropriate fact pattern to be using more discretionary language, less restrictive language, but accomplishing the same goal moving forward. And I think it gives the family a better feeling. It certainly gives the individual a better feeling to do that. Another thing to keep in mind when you're creating these trusts is use life insurance. If you have a life insurance policy and you're naming your children as beneficiaries of this policy, make sure you've got a trust in place for the benefit of your special needs child, and that his or her share is going to go into that trust. The trust has to be in existence before you die in order to receive the benefits, but it's a good way to put a nice chunk of change into a special needs trust. Be careful. The kind of the last thing I want to talk about here in terms of special needs trusts is, oops, go back. The issue of choosing the trustee. It is my opinion, I'm going to underline that and put it in bold caps, that having John's sister as the trustee of special needs trust is the worst possible thing you can do in the whole world. You are destroying a filial relationship, and you are creating a dependent relationship. Other people will disagree with me, and they do all the time, but I think, yeah, Jane will take care of John, or John will take care of Jane. I don't want to be sexist, but it rarely really works. It creates stress among the siblings, and I just don't think it's a good idea from a family relationship standpoint. Trust companies or banks, you're going to need to have a good 7 figures in your trust for any of those institutions to get involved. I would say if you're going to have a trust that is funded with less than $300,000 or $400,000, you ought to be looking at one of the pool trust subaccounts. Because the cost of creating a private special needs trust I don't know rates in Orange County. Out my way, you're looking at anything, something north of probably $5,000 to $10,000 in creating that document. And then you've got the ongoing maintenance of paying a trustee, of filing tax returns. So in order to make it, and all of that is money that's not going to the beneficiary. So I would give serious thought to using one of the many private professional fiduciaries that are out there. And I know there's some very, very good ones in Orange County. Many people talk about having trust advisory committees. I think they have their place, but I would use them sparingly. If you've got someone, I would much rather, if you were concerned about whoever you've chosen as your trustee, to know what John needs. And I didn't put it here in the slide deck, but there's a thing called a letter of intent, which is your way of sending a letter, back to Judy's point, a letter to the future. Here's what we hope for John. Here's what we would like to see happen. Let us tell you about John. I'm putting it on my list, Judy. I will send you a template for an LO, a letter of intent, in addition to the other things I'm going to forward to you. Resources for all of this, the place to go for information on conservatorships, on special needs trusts, for care managers, for private professional fiduciaries. This is the go-to people in all of it. So PFAC, Professional Fiduciaries Association of California, great organization in terms of looking for someone who can be the trustee of special needs trust.
And just to add to that, we have a meeting in October with 2 fiduciaries.
Great.
So,
Great.
Hitchman and Associates and
Oh, yes.
Merlin.
Absolutely.
So,
Absolutely. Know them well.
One is kind of more independent. One has built a whole organization, so it gives you a different kind of feel for it, and it'll be really helpful for you to get a sense of what a fiduciary can do and how it works. I think we've previously had a session on that, so you can go back and watch a session on fiduciaries. So Stuart, there are some questions.
Yeah, just before I take the questions, I just want to point out, for anyone who wants more information, more in-depth information about different kinds of special needs trusts, the last one there, the Special Needs Alliance, has a huge amount of consumer information on special needs trusts, and I think it's a go-to site. All right, questions?
Okay, hold on. There were quite a few.
I would have rated that.
Okay, hold on. Okay, I'm familiar with the cost of special needs trusts. Are the supplemental needs trusts around the same price range as special needs trusts, since they are similar?
I say they're identical. I mean, as I said, they're a synonym, so I would be pricing them the same. Discretionary trusts might be a little different, but yeah, I would say the pricing for that, at least in my neck of the woods, is the same.
Thank you. Okay, Hannah wants to ask a question verbally.
Yes. Yes, I'm there.
Okay.
I am asking when I'm doing a trust for myself, so I'm the trustee, but then I'm putting that if I die, my kid now who's special needs, it doesn't say on top special need trust, it's just a trust, but the lawyer said then automatically it becomes a special need trust. So first I want to know if that's true. And then with what you said, then there is executors, but there is no, if I pass away, there is no trustee then on the account, because they're just executors for the money that is left there.
Okay. Since I haven't read the document, I can't answer the question. I would say to you, in a trust, a family trust that I would be creating for a couple who has a child with a disability, the best way I can answer your question, I think, is like this. I would be creating a trust for you and your husband that would be in existence while both of you are alive. And when both of you are deceased, that document would then contain another trust built into it that is a special needs trust for your son with a disability. So yes, in the context that I'm describing, yes, when you are both deceased, the next trust that's created for your son would be automatically a special needs trust, because that's the way I wrote it. Okay.
But it doesn't have any specification. It just left like that. It just says a line that says after we pass this, it's a special need trust, and that's it.
No. Yeah. In the trust I would be drafting, there would be a whole new section that says this is Johnny's special needs trust. And your trust says, look at it this way. On page 14 of your trust, it says, when we are both dead, whatever assets are left go to Johnny's special needs trust, which starts on the next page. And then it's a whole different trust, but it's built into one document. It's a different room in the house. Okay, if your trust truly doesn't say that, with respect to your lawyer, I think you need to see another lawyer, but I don't know your document.
I see. But so I have to read that inside it, there is a line, what happens when I pass away.
Correct.
I got it. Thank you.
Oh,
I have another quick question. You know how we said about housing and doing an ABLE account?
Right.
So can a trust cover then the utilities and property tax?
No.
Or anything related to housing is a no-no?
Anything that perfectly said. Basically anything that has to do with housing is a no-no. In the Social Security regulations, there are 10, the term housing, it has 10 parts to it. And property taxes, insurance, homeowners association dues are all part of that. So no, it can't do that.
So SSI is like
The able
SDI?
account can. I'm sorry?
SSI is like SSDI, or is
No,
there
no, 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 no,
difference?
no, no, no. Oh, no, no, no. Going to Sesame Street, D is the most important letter in this whole world of Social Security. Social Security disability is one thing. SSI is a whole other thing. The two have nothing in common other than three letters, which they shouldn't have together. SSI is completely different. It has no restrictions.
You mean
Oh,
SSDI?
SSDI has no restrictions in the trust.
SSDI has no restrictions other than you can't be able to work. But that's a whole other conversation for another night.
Thank you.
Okay, and one thing I just want to add on there is if you're on SSDI, but you happen to have Medi-Medi, then you have Medicare, and then you get some whole new restrictions as well. I mean, you have Medicaid, so there's some additional restrictions as well. So, okay, I'm going to continue with the questions, Stuart.
Yep.
Can the person also be his own trustee? I think it depends on the type of.
Absolutely not.
Okay. How can a special needs trust be revoked if the individual wants to earn money and grow money?
Well, okay. Earning money and growing money are two different things. If the trust, hopefully the trustee of the trust is going to grow the assets. Earn money, that's a whole different conversation. There are a number of Social Security programs that exist. Ticket to Work is the one that just pops into my head. But if the person has the ability to work and they're on SSI, I strongly suggest that they get in touch with their Social Security agent's local office and explore, or go online and explore the various work options.
Actually, the best resource for you there is Department of Rehab or the Regional Center, and they have someone called a WICA, which I don't know what it stands for, but that is a person that can advise you if you're receiving benefits, how you can continue to receive your benefits when working. So it's a very, very important question that you're asking, but you need to go to the right people to get the best advice on it, because you could get in trouble. You can find yourself losing benefits or things if you don't understand it. So very good question. That's the right resource. Okay, so then next question is, what is a private fiduciary company? You want to give an example?
Well, Hickman and Associates, who are going to be speaking next month, they're private professional fiduciaries.
Yeah.
And
it's a bonded organization that is, they have to go training, and it's like licensed, and they have ethics classes, and they're set up many times by the court to be responsible for managing a person's day-to-day and their financials when they act as the trustee when you've passed. Is that a good explanation?
Yeah, it is.
That's a layman one.
Yeah, they're licensed, they're bonded, they're trained. They've got, in a sense, they go through sort of the same kind of internship program that other professionals do. They've got to, in order to get their license, they have to do several thousand of hours of training under supervision. And if I wouldn't be talking to any private professional who wasn't a member of PFAC. But many of them come from the social welfare world. Many of them come from the financial world. And many of the companies, I don't know whether Hickman's one of them, have people on both sides of that equation. They've got someone who understands finance. They've got a social worker, licensed social worker. Some of them are RNs. But yeah.
Okay, the next question is, it's a longer question, can trusts replace wills, or do we need both?
Okay, great question. As an estate planning in California, and all of estate planning is all state specific, so I'm speaking only for California. In a well-planned, well-drafted estate, the primary document is the trust. It's where the action is, it's where the assets are, that's where all the instructions as to what's going to happen. But every well-drafted estate plan is going to have a will. And what the will says is, if I forgot to put any asset into the trust so that when I die, I've still got this bank account that I set up and forgot I had it, and it's now sitting out there in my name, not in the trust name, I hereby bequeath it to the trust so that everything ends up being in the trust. And it's called a pour over will because that's what it accomplishes. It pours over that bank account you forgot about into the trust because that's where the action is. So yes, the trust is the sun in the middle of the solar system, and the will is Venus kind of out there someplace. But yes, in a well-drafted estate plan in California, you're going to have both.
Okay, since you brought up location, that's the very next question from this person. Are all these location dependent? If we move from a different state, county, does the person needs to be consulted or informed before filing conservatorship? That's different than a will and trust, but
county, no. State, yes.
Okay.
Conservatorships are, again, state dependent. There is an act that's been adopted by, I think, every state at this point, where a conservatorship can be transferred under most circumstances between one state and another without starting from scratch. That doesn't apply to limited conservatorships in California. If you've got someone who's under a limited conservatorship in another state, it cannot be transferred to California because California's requirements are different than most other states, of course. So you start from scratch with a limited conservatorship.
Okay.
As far as counties go, if the conservatee, the person who's under conservatorship, moves to another county, the court needs to be notified, and then the court will generally be the one triggering a transfer of the file from one county to the other.
Okay, Stuart, can you only have one type of trust, first party and pooled?
No, I've got any number of clients where there's a first party trust that got John's PI settlement and a third party trust that his parents set up for him for when they die.
Okay,
and in some cases, yeah, there may be a pool trust as well, pool trust sub account as well.
Okay, the next question is, an ABLE account tied to any trust or independent and can I apply now? It's independent of trust.
It's totally independent of trust. ABLE accounts exist in their own world.
And you can apply now, and it only takes 5 minutes.
I won't go that far, but yes. And ABLE accounts differ between jurisdictions. Yeah. There are some restrictions on what kind of assets an ABLE account can hold. So some people go to a state outside of California where it'll hold certain kinds of stocks or bonds or something that the ABLE account in California won't hold.
I didn't realize that.
Yeah.
Okay. Our trust discussed apply to children over 18.
Say again?
It's a difficult question. Our trust discussed applied to children over 18. So basically what you talked about today was only really focused on children over 18.
Well, in the term, well, yes and no. In terms of conservatorships, absolutely. Conservatorships are for people over the age of 18. But if, God forbid, I have any number of trusts that we've created in our office where we're setting them up. We're setting up special needs trusts now, third-party special needs trusts for very young children, because we anticipate that they are going to receive significant sums from a grandparent well before the parents die. So we want to have that trust in place. And these children are very young minors.
Okay.
Now, there's no reason it can't be done. No.
So the next question is about oversight. Who oversees the trustee, professional fiduciary, if something unfair happens and the disabled person does not advocate when we are dead? Worried about cases where we are trying to help our son, but it ends up leaving him homeless or with a big fight to get access to what he needs.
That's a good place where a trust advisor or a trust advisory committee would be in place. So somebody who will receive reports. All trusts in California are required to file, to do an annual accounting. And give a copy of that accounting to the beneficiary or anyone else who's named in the trust. So for this person, I would suggest they discuss with their attorney, naming someone or some buddies to receive copies of the accounting. And if something looks untoward in the accounting, or if one doesn't show up, then under California law, that person who was supposed to have received the accounting has standing, as we call it, to drag the trustee into court and answer to the court as to why they weren't doing what they're supposed to do. And if the court finds there's been malfeasance or misfeasance, they can be removed, they can be censured, pilloried at the stake, whatever.
Yeah, I think my comment to Edgar is a well-drafted special needs trust will help you prevent those kind of malfeasance from happening, because you'll build in some oversight. Right. So that, I mean, I have heard horror stories. I have heard a story where parents had a special needs trust, but they gave the child the ability to choose who the trustee was. And he chose somebody in his church, convinced him to use them, and they spent all his money and sent him on a one-way flight to South America. And then years later, they were working on fixing it. Or a cousin was put, and they had their own desires for the money. Right. So there definitely are stories of that. But if you construct the right kind of trust that has oversight, that other people are watching to make sure that if something bad happens, that it's prevented from happening, or, you know, that they can see what's going on and change the trustee, then I think you're safer.
Yeah, you're absolutely right. Another thing to consider is you can require that the trustee provide a fiduciary bond, a guarantee against her malfeasance. They're not cheap. They're an expense of the trust. And in some cases, it solves the problem of someone who would like to be the trustee, who you might like to be the trustee, but you say, well, you got to get a bond, and those 3 prior bankruptcies and the felony conviction for embezzlement are just going to prevent him from getting bonded. It's something I am recommending more and more to my clients. Okay. I don't care how trustworthy you think Uncle Bernie is, he needs to be bonded.
Okay, Hannah, I see your hand up, but I'm going to do just the next 2 questions, and then we'll go to Hannah. I'll let you finish probably. Do you want to continue? Are we close?
Well, all I can say is I know my wife's making dinner, so I can't.
Okay, well, all right. Well, we better
too much longer, but okay.
Yeah. We'll take a couple more questions. How do we find the right attorney that specializes in these things?
Special Needs Alliance. Okay, I go to the Special Needs Alliance website. I would also go to the National Academy of Elder Law website. You've got some phenomenal attorneys in Orange County. I'm not going to play favorites and name names unless you twist my arm. Okay, you can twist my arm. McGonigal and Hunsaker down in Laguna Woods. Just a great law firm. They are my go-to Orange County firm, but they're not the only ones.
Okay. Edgar's trying to carve up something here. Is it best to have different trusts with different trustees for the same person to protect in case something goes wrong with one trustee, or assets get lost in some cybersecurity incident or other unexpected case?
No. I mean, you know, you can't. You can't protect against everything. The only, in my opinion, the only, and actually, I'm in a world where I try and consolidate trusts. Where I've got a divorced family, and one parent is creating a special needs trust, and the other parent's creating a special needs trust. I try and get them together and say, hey, you know, put your differences aside, join together, create one trust for John. And each of you in your trust estates put the money in there, and, you know, just do it for John, because having multiple trusts is multiple tax returns, multiple CPAs. Why? There's sometimes when you have no choice, but especially when you've got a first party and a third party, but having 2 third-party trusts running around, if it could be avoided, makes no sense.
Yeah, and then if you're going to have multiple trustees, then you're watching multiple things go. I don't know. It sounds complicated. It sounds complicated.
It is.
Well, Hannah will be our last questions, and then we'll let you go eat, Stuart. So Hannah?
Yes, I just have a question. If I put my accounts that upon death, it goes to the trust account, I that is my trust account?
No,
Does that work or
no,
no?
no. Okay, no. Pay on death accounts work like joint tenancy accounts. In a pay on death account, you're going to name somebody to receive the benefits on your death. If you want that particular asset to be in the trust, then you retitle that asset into the name of the trust. You don't do it as a POD. That's my opinion. That's something to discuss with your estate planning attorney.
Okay, and what's the name of the lawyer, please, again, that you said?
Thank you.
It's McGonigal, McGonigle, and Hunsaker, Hunsaker.
Thank you.
And they did not pay me to make this announcement.
Okay. Well, thank you so much.
It's been my pleasure. Lovely meeting all of you. Take care, and I'll get those materials over to Judy as soon as I can, probably late in the week.
Okay,
And
sounds
Judy,
great.
have a good evening.
Thank
Thanks for
you. Thank
joining
you,
me.
everybody. Take
Take
care.
care. Bye-bye.
Bye.